back in 2011, I had a chance to meet Marshall Wagner and the members of the ERISA practice. And at the time, they had a national reputation of being terrific ERISA employee benefits attorneys. But they didn't have an employment lawyer, and they had a void. So I moved from New York to Boston to fill that void and to build out an employment and HR consultant practice with an incredible group of people. And it's been an honor and a pleasure to work with them over the last 5 years. Really some talented, fun people to work with. On December 1st, we were supposed to have the new Department of Labor regulations regarding overtime exemptions going into effect, and that was going to increase the amount of money that a person needs to make in order to be considered exempt. On November 22nd, just 8 days before this was supposed to go into effect, a federal judge sitting in Texas issued an injunction. That means that the new overtime regs are not going into effect. Now, what this does is makes it very, very complicated for employers, because if you offer somebody a higher salary, or you hire someone and you tell them, for example, I'm going to pay you $48,000 a year, but now that the rule is not going into effect, you want to claw that back, and instead of making it $48,000, you want to make it, let's say, $25,000 or $30,000. You can't necessarily do that because the employee could turn around and sue you for a breach of contract, possibly unjust enrichment, detrimental reliance, and things along those lines. So you do face potential legal consequences. You also face potential employee engagement consequences. If you take back what you offered employees, they're going to get upset. Much like Major League Baseball, if they had a walkout, you've got tremendous dissension between players and owners. You would have the same thing in a company between its employees who are no longer making what they thought they'd be making, and as a result of that, you run into employee engagement issues, morale issues, productivity issues, and it affects your brand. The other thing we're talking about right now is that the Equal Employment Opportunity Commission revised something called the EEO-1 form. That's a form that employers with 100 or more employees have to file on an annual basis, and it's a report based upon gender and race and ethnicity that has to be reported to the EEOC so they can get a sense of how many people are at different levels in a company based upon race, based upon ethnicity, based upon gender. What's happened is the EEOC has changed this. And now, in addition to the census, they also want to collect pay data. This is going to go into effect in March 2018. What happened is the EEOC, which was formed in 1965, has decided it has not been doing a good enough job creating a workplace free from adverse decisions made based upon gender, based upon race.
So unfair compensation.
Absolutely.
Okay.
And what they've done is they've taken two things. One, they've taken all the greatest technology, computer programs, software, and all that. And two, they've taken the fact that they haven't done a good enough job, and they're saying, give us this information so that we can press a couple of buttons, and without a whole lot of work, we can identify those companies that are not paying their employees fairly. So what basically companies have right now is they've got a window between now and the end of 2017 to get it right. And if they are not paying people fairly, the EEOC is going to find out, and they're going to pursue claims against these companies. They could be very expensive because you could be looking at lost wages, going back for several years. You can also be looking at punitive damages, counsel fees, class litigation.